you don't have to look very hard to realize that all of the inequalities that we see in literal markets already exist in the civil justice system. The idea is that there is a gap between the law on the books, which is the law as we might imagine it to be, or the law as it's written, and the law in action, what actually happens to people when they find themselves in court. I'm William Hubbard. I'm a professor at the University of Chicago Law School. I'm currently serving a term as deputy dean as well, and I'm a research professor at the American Bar Foundation. I have a background in both law and economics, and my research takes the tools of economics and applies them to help answer questions about how the legal system works. In my research on civil procedure, one of the things I focus on is the federal rules of civil procedure. Now, the federal rules of civil procedure were first created in 1938, so they're almost a century old. And one of the things that I've come to understand in my research is the ways that the federal rules have become outdated over time. The first way in which the federal rules have become outdated is they're based on a model of litigation that involves a single party suing a single defendant, one plaintiff and one defendant. A second way in which the rules of civil procedure have become outdated over time is they're based on an assumption of a rough parity in terms of the resources and legal representation of the plaintiff and the defendant in a lawsuit. That may or may not have been true back in 1938, but it's definitely not true today. One of the important ideas that I really try to develop in my research and teaching is what I call the paradox of procedure. It's very natural when we see an injustice in the legal system, when we see inequality in the legal system, to say we need to protect those who are disadvantaged by giving them more rights. And that means more procedure, more ways to use the system. The paradox here, though, is as you add more and more rights, you're adding cost and complexity to the litigation process. And cost and complexity is what litigants who lack resources and who lack sophistication are least able to handle in the legal system. And in fact, it's the wealthy and sophisticated parties that can use cost and complexity to their advantage in the system. In my current research, one of the things that I'm trying to do is explore new and creative ways to solve or address the paradox of procedure. One of the innovations that I've seen some state courts employ is what I like to call lightning lanes, named after the lightning lanes at Disney World that allow people who pay more to get to their rides faster. Now, you might think the idea that people who pay more can get something faster is the exact opposite of how we want courts to operate. And that's a completely natural reaction. And that may, in many contexts, be the correct reaction. But here's the interesting thing about lightning lanes. It's already true today, even without them, that a party with more money can use procedure to speed a case up. The difference between a lightning lane and the current setup today is that in order to get ahead in a world of lightning lanes, you have to pay the court money in order to get that advantage. What that means is the court now has revenue that it can spend on providing court services to those who can't afford them themselves. A lightning lane still advantages those who are willing to pay, but the revenue from those lanes allows everyone in the court system to have better access to justice. And by expanding the capacity of courts, cases start to move through the courts faster. What that means is even the cases that aren't in a lightning lane are going to be moving through court faster, benefiting everyone. In our book, we talk a lot about congested courts and the effects that has on litigants who aren't able to get access to justice because of congestion. A solution that we propose is congestion pricing. This is a solution that a colleague at the ABF, Danny Wolf Townsend, has also proposed for debt collection courts in particular, where sophisticated filers are overwhelming the courts with thousands of filings. The idea of congestion pricing is something that has made the news in other contexts. For example, New York City implemented a congestion pricing program where anyone driving in Lower Manhattan has to pay a fee to do so. The effect of that congestion pricing scheme was both to raise revenue for the city and to reduce traffic so the traffic would flow faster and drivers and pedestrians alike would have faster commute times and safer commute times. The idea in court is similar. The heavy users of the court system, the users that are really gumming up the works and using it to their advantage, they should have to pay more because they're imposing a cost on everyone else in the system through their heavy use. A natural question that a person might have is, gosh, market forces can be drivers of inequality. Shouldn't we just try to get rid of them? And our answer to that is pretty simple, really. It's that there's no way to do that. We live in a market-based society, and people pay for lawyers. People pay fees to go to court. And that economic inequality that exists in society, that ability to buy and sell things that help you achieve your ends, is always going to be present in the legal system as well. So the only choice we realistically have is between wishing away something that isn't going anywhere or trying to proactively regulate it in a way that serves the public good rather than letting it continue in an unregulated and unfettered way. I hope that my research also offers concrete suggestions, concrete proposals for specific things that courts and lawmakers can do to change procedure. For example, the idea of congestion pricing is not merely a thought experiment, but it's a concrete proposal for how filing fees could be structured in a way that better protects those who have the least access to court. And so as a lawyer and as an economist, I like to think about the ways that the choices that we make when we design courts, when we design procedure, the ways that those choices affect the incentives of lawyers, of judges, of plaintiffs and defendants, and how those incentives shape the outcomes and the inequalities that we see in the system. I'm hopeful that my research will have an impact on not just the legal academy, but the legal profession and the public as well.